Green card holders, these three changes took effect in July 2025. If you're a green card holder living in the US right now, stop what you're doing and listen closely. Three major immigration policy changes have just gone live, and they directly affect your legal status. This isn't rumor, hype, or speculation. These are real, confirmed government actions being enforced as of July 2025. If you travel, file paperwork, or have any pending green card issues, your next move could determine everything. In this video, we're walking you through all three: what's changed, who it hits hardest, and how to stay protected in today's risk-heavy environment. Green card travel just got a warning label. U.S. Customs and Border Protection has begun flagging green card holders who attempt to re-enter the country with unresolved legal, financial, or immigration-related issues, even ones from years ago. That means an old traffic violation, a late tax return, or an unresolved court fine could now trigger extra screening at the airport. These aren't theoretical warnings. They're being enforced today. Green card holders are being questioned for minor things. Secondary inspections are increasing. Legal permanent residents have been detained for hours and, in some cases, even referred to immigration court. One New Jersey-based software engineer returning from a family trip to Turkey was held for over 7 hours in May. The reason? A 2019 traffic citation that had been dismissed but was never cleared in DMV records. She was warned that her green card could be sent for revocation. That's the level of scrutiny now being used at U.S. ports of entry, even for long-term, tax-paying green card holders. If you have travel plans this summer or fall, now is the time to review your full legal record. Not just serious issues, even minor mistakes could block your re-entry or delay your return. Customs officers now have real-time access to your tax filings, DMV records, old addresses, and foreign travel patterns. If anything is outdated or inconsistent, it could raise red flags at the border. Re-entry delays are no longer just a headache. They could escalate into full immigration proceedings. And under the Trump administration's 2025 enforcement directives, officers are being told to act swiftly. Birthright citizenship now depends on where you live. On June 27th, the Supreme Court delivered a ruling that allows Trump's executive order limiting birthright citizenship to go into effect in certain states. The consequences are historic and immediate. For the first time in modern U.S. history, a child born on U.S. soil may not automatically become a citizen if their parents are undocumented and if they're born in a state enforcing the rule. This means that starting late July, states like Texas, Florida, and Arizona could begin denying citizenship to children born to undocumented parents. Other states may be blocked by federal injunctions, but not all. The situation is now a legal patchwork, and it's affecting real families today, especially green card holders who are sponsoring pregnant spouses or planning to give birth in the U.S. this year. Citizenship is no longer a national guarantee. It's now conditional, based on where you live and how your local courts interpret federal authority. Immigration lawyers are calling this a legal minefield. If you're a permanent resident planning for a child in 2025, do not assume that U.S. citizenship will be granted at birth. Depending on your state, that assumption could be wrong and costly. This isn't just about a baby's passport. It affects your family's future. That includes school access, Medicaid eligibility, future sponsorships, and the ability to apply for derivative immigration benefits. Green card holders are now being urged to seek legal counsel before giving birth, especially in states where enforcement is likely. You may need written documentation to establish your child's citizenship claim later. What used to be a simple hospital birth has become a state-by-state legal gamble, and this isn't expected to be resolved anytime soon. Lawsuits are pending, but the rule stands, for now. Medical exam validity now ends after denial. Here's the third major change, and it's catching applicants off guard. As of June 11, 2025, if your green card application is denied, withdrawn, or closed, your medical exam becomes invalid, even if it's still within the 2-year window. Previously, you could reuse your I-693 medical exam if you reapplied within 2 years. That's no longer the case. USCIS has quietly ended that grace period, and it's already impacting green card applicants this month. What this means is simple. If your I-485 adjustment of status is denied or withdrawn for any reason, you'll now need to pay for an entirely new medical exam if you plan to reapply. That includes scheduling a new civil surgeon visit, undergoing another round of testing, and resubmitting the I-693 form. The typical cost? Anywhere from $200 to $400 depending on your state. Many applicants delay reapplying for months, even years, after a denial. Under the old system, they could reuse their existing medical paperwork. Under the new rule, that option is gone. So what's the smart move? Only file your I-485 if your case is fully documented, properly reviewed, and ready for approval. Because now, a weak application won't just waste time, it'll cost you double. Final checklist: what you must do now. If you're a green card holder in 2025, this summer is not the time to take chances. Before you travel, sponsor a relative, or file anything with USCIS, take these actions seriously. Check your legal records. That includes traffic violations, dismissed court cases, IRS tax returns, and old address history. Fix anything that's incomplete or unclear, no matter how minor it seems. If you're planning international travel, prepare proof of ties to the U.S. Recent pay stubs, a lease, utility bills, W-2s, anything that shows strong, ongoing presence in the country can help. If you're expecting a child in 2025, especially in a state like Texas or Florida, don't rely on assumptions about birthright citizenship. Ask an attorney about the injunction status in your state and get written advice. Track your I-485 status closely. If your case is ever denied or withdrawn, redo your medical exam as soon as possible. Don't wait months and risk losing time or missing a window to reapply. Rumors you should ignore. There's a lot of misinformation spreading on TikTok, YouTube, and WhatsApp right now. Let's clear the air about what's not true, at least not as of July 2025. There is no law allowing early naturalization for green card holders after 4 years. That's false. The 5-year and 3-year rules still apply. There's also no 180-day rolling travel limit that automatically triggers revocation. Travel limits are real, but they're case-specific and not automated. You are not required to prove your employment field annually if you're an EB2 or EB3 green card holder. That's another fake headline. And while USCIS is digitizing some processes, there is no mandate for 100% digital green card renewals starting late 2025. That's not official policy. Stay sharp, stay legal. Green card holders, 2025 is not the year to get comfortable. Immigration enforcement is evolving faster than most people realize, and small mistakes are now turning into life-changing problems. You've come too far to lose everything over a tax form, a traffic citation, or a missed filing. Protect your future by staying informed, reviewing your records, and double-checking with professionals before making decisions. If this video helped you stay one step ahead, hit that like button, subscribe, and turn on notifications. We're tracking every change so you don't miss your chance at a secure immigration future.